Hi everyone, it's James from Community Legal Centres Queensland here. For those that have played before, can I ask you to press the hand button just to put your hand up just to let us know that you can hear me okay? Terrific. There's a whole heap of hands going up, so I'll take it that the sound is working okay. Thank you. Good morning and welcome to another one of our webinars. Can I begin this webinar by acknowledging the traditional owners of the lands on which we're electronically gathered or dispersed, or however you want to describe it. So I acknowledge traditional owners here in Brisbane, where Nigel and I are delivering this webinar, the Turrbal and the Yagara people, but acknowledge traditional owners and First Australians across Queensland. And across Australia, because we do have a few people tuning in from outside the state, I think. I think it's particularly important to recognise Aboriginal and Torres Strait Islander peoples in the context of this discussion, given that Aboriginal and Torres Strait Islander children are almost 10 times more likely to be in foster care or other forms of out-of-home care. So the things that we're talking about today and the work that you're all doing in this space is particularly relevant. For those that haven't tuned into this webinar technology before, just a couple of housekeeping things before I hand over to Nigel, our presenter. A copy of Nigel's PowerPoint presentation is available in the handouts area of your control panel, so you should be able to download that. We'll also email around a copy in the next day or two. There are a couple of ways that you can ask questions as the webinar is progressing. You can put up your hand, so there's a button that looks like a hand on your control panel. That's the one that a few of you are just hitting. We'll see something that looks like a hand popping up beside your name, where you can unmute your microphone and you can ask a question. The other way that you can ask a question is to type a question into the questions box. We'll see that here. Maybe paraphrase it and then give you a response. Webinars aren't great for that kind of conversational interaction though, so if you can hold your questions over until the end of the presentation, that would be useful. And I think that's more or less the housekeeping things. We will try and record this and post a copy of the recording to our website and send that link around to you, but as always, we're in the fickle hands of the technology with that, so I can't 100% ironclad guarantee that. Folks, without anything further from me, can I hand over to Nigel Miller, who's the Acting Assistant Director of Family Law Services at Legal Aid Queensland. His day job predominantly is in this child protection space, and he's really well qualified to give us a bit of insight into some of the changes that are happening in the child protection space. There's been a lot over the last couple of years, or foreshadowed over the last couple of years, and some of those will be implemented in the next little while, and I think are really important for us to understand whether we're providing general advice in family law matters or looking to do a bit more specialist work in this space. I'll hand over to Nigel. Thanks, Nigel.
Thank you, James. Now the focus of today's webinar is really going to be on the upcoming reforms that are going to take or come into effect on the 1st of July 2016. In Queensland there was a Child Protection Commission of Inquiry that undertook its work in 2012 and 2013 with its final report, Taking Responsibility, a Roadmap for Queensland Child Protection, presented on the 1st of July 2013. That report made 121 recommendations that are aimed at building a sustainable and effective child protection system over the coming decade. The government responded to the inquiry's final report in December of 2013 and accepted 115 of the recommendations in full, and the remaining 6 were accepted in principle. Implementation of those recommendations is underway right now. You will have already noticed, for example, the establishment of the Office of the Public Guardian in 2014, and that includes a role in providing advocacy for or on behalf of children and young people in care through their child advocates. And there's also been the development and implementation of a new framework for child protection practice for child safety staff. Now in 2016, so from 1 July, there's going to be a focus on the children's court processes, and they're going to be improved by justice-related amendments to the Child Protection Act and the remaking of children's court rules. Those rules and the amendments to the Act will establish a court case management framework for child protection proceedings. And there's also going to be the establishment of a new office within child safety called the Office of the Child and Family Official Solicitor. And there's going to be a new agency established called the Office of the Director of Child Protection Litigation. So that's an independent agency that will sit within the Justice portfolio. These changes are intended to reform court processes to achieve better outcomes for children and their families by ensuring that their voices are heard in decisions that affect them, and also improve the quality of evidence supporting applications, minimising delay and ensuring the court has all the relevant information it needs to make a decision. The justice-related reforms are going to be followed by a comprehensive review of the Child Protection Act, and that's already started, or it's underway. So the Director of the Child Protection Litigation Act is going to establish the Office of the Director of Child Protection Litigation. It's going to be an independent statutory agency to litigate applications for child protection orders. So that will include deciding whether to apply for an order, and if so, what order is going to be sought. The intent of this reform, which is unique among Australian child protection systems, is to provide greater accountability and oversight for child protection order applications proposed by child safety. It's going to ensure that the applications filed in court are supported by good quality evidence. It's going to promote efficiency, and there's going to be evidence-based decision making. As well as working collaboratively with the DCPL on child protection proceedings, child safety will retain responsibility to litigate assessment orders and temporary custody orders, including deciding whether to apply and what order to seek. And so it's going to be the Office of the Official Solicitor, which is OFCOS. OCFOS has been established administratively within child safety to support these functions. Now, Section 66 of the Child Protection Act provides that a court may adjourn a proceeding for a court assessment order or a child protection order. So subsection 4 is going to be amended to clarify that the court is able to make directions to child safety or to another person that the court is allowed to participate under section 113 of the Act on an adjournment of a child protection proceeding. So in respect of child safety, this provision has been amended as in child protection proceedings from 1 July, child safety will no longer be a party to the proceeding. Child safety will be in essence considered a witness to the proceeding, but that amendment will assist the court in still being able to provide directions to child safety on any adjournment. Another big area of reform come 1 July is going to be disclosure. The need for a continuing duty of disclosure for child safety was considered by both the inquiry and the Children's Court Case Management Committee established after the inquiry. Legislative amendments in the Child Protection Act and the Director of Child Protection Litigation Act address their recommendations. So Section 189(c) of the Act will impose a duty on the Director of Child Protection Litigation to disclose all documents in their possession or control that are relevant to the proceeding or relevant to the proceedings of the other parties. Any document in the possession or control of child safety is deemed to be in the Director of Child Protection Litigation's possession or control. It's important to note that this duty does not oblige the Director of Child Protection Litigation or Child Safety to create or obtain a document so that it can be disclosed to the parties. For example, if the parties consider that a health service holds relevant documents, these legislative provisions do not oblige child safety or the DCPL to obtain those documents if they don't have them. although there may be other ways to approach this kind of problem, such as subpoenas. Section 189 capital C subsection 8 provides that the rules of the court may make provision about disclosure under this section, including the time by which a document must be disclosed. Now, in respect of disclosure, there's going to be an amendment made to Section 191 of the Act, which will provide grounds for when the Director of Child Protection Litigation may refuse to disclose a document to a party. In addition to the grounds for refusal shown on the slide, Section 191 will also allow the Director to refuse disclosure where the document is or contains personal information that is not materially relevant to the proceeding, or the disclosure would be contrary to public interest, or there's another good reason not to disclose it having regard to the best interests of the subject child. These grounds can also be relied upon by anyone else engaged in the administration of the Act to refuse to disclose information, or rather than a document, to any court, tribunal or party. In respect of another area of reform will be a court case management framework being established. Legal Aid Queensland's submission to the Child Protection Inquiry was that a case management process would be a significant improvement for child protection proceedings. Legal Aid's submission suggested that features of such a system would be early consideration of who should be involved in a proceeding and the need for legal representation for parties, particularly parents, and promoting early resolution of issues, including obtaining directions about disclosure and expert reports. The need for court-led case management framework for child protection proceedings was considered by both the inquiry and the Children's Court Case Management Committee established after the inquiry. The court case management framework will be supported by amendments to the Act and the remaking of the Children's Court rules. The Court Case Management Committee has endorsed a court case management framework made up of the Children's Court rules, practice directions and a bench book for magistrates. The rules of the court will underpin the case management system. The court case management of a matter will be led by the magistrate or judge dealing with the matter and should provide a flexible framework for managing a proceeding consistently with the principles of the Act and appropriately given the nature and complexity of the issues in the particular case. In addition to the framework proposed by the committee, some provisions and amendments to the Act will particularly support proactive court case management. A new section 68 capital A will clarify that when the court orders that an expert report be prepared, the court may also direct that the report writer be permitted to view or be given a copy of a relevant document or other information before the court. Section 114 already allows a magistrate to transfer a proceeding to be heard at another location, either on its own initiative or on the application of a party. However, there will be an amendment to Section 115, which already allows a magistrate to hear two or more applications together. It will be amended so that this may also be done on the court's own initiative or on an application of a party. Currently, this can only happen on the application of a party. Another area of focus in terms of the amendments is the representation of children. Section 108 provides for the right of appearance. The amendment to Section 108 of the Act aims to clarify that a child may appear in person or may have a lawyer who acts on their instructions or a separate representative or both. Definitions of both direct and separate representatives will also be provided in the Act. It should also be noted that in addition to a separate representative, which is a best interest lawyer, and also the direct representative lawyer who acts on instructions, it's also possible for a child now to have an advocate from the Office of the Public Guardian in the proceeding. This amendment goes directly to one of the overall aims of the court reforms, ensuring children are heard in decisions that affect their lives. It is anticipated that Children's Court rules will provide a more detailed framework for supporting children's participation in a proceeding. So in that respect, the proposed Children's Court rules, the remade Children's Court rules, have not yet been released, and so this is going to be waiting to have those rules in place by 1 July. Section 110, which provides for the appointment and role of separate representatives, is going to be amended and will apply only to child protection proceedings, meaning that it will no longer be possible for a separate representative to be appointed in proceedings for a court assessment order. Without limiting the court's existing wide discretion on when to appoint a separate representative for a child if the court considers it necessary in the child's best interests, the amendments will provide that the Children's Court rules may prescribe matters that the court must consider in deciding whether to make an order appointing a separate representative for a child. As amended, Section 110 will also outline a minimum set of duties for a separate representative. It will require that, taking into account the child's age and ability to understand, a separate representative must meet with the child, explain their role to the child, and help the child participate in the proceedings. The purpose of these amendments is to strengthen the representation of children and young people in proceedings for child protection orders by ensuring a separate representative has comprehensive knowledge of the child's case. It will remain the case that, as far as possible, the separate representative is to present the child's views and wishes to the court, and that the separate representative must act in a child's best interests regardless of any instructions from the child. The amendment to Section 110 regarding the duties of a separate representative effectively codifies the requirements of Legal Aid Queensland's case management standards in this area. There's going to be a further amendment in respect of court-ordered conferences. So court-ordered conferences were considered by both the inquiry and the Children's Court Case Management Committee established after the inquiry. The inquiry recommended that the committee consider the issues and propose any recommendations to support a legislative framework for court-ordered conferencing at critical and optimal stages during child protection proceedings. The committee recommended that the court should have the discretion under the Act to dispense with the requirement to order a conference in contested proceedings if it would be inappropriate to hold a conference. And this recommendation will be implemented through changes to Section 59, subsection 1C of the Act. The committee also recommended further guidance for court-ordered conferences should be included in the Children's Court rules, bench book and practice directions. It's important to realise that even without amendment, a court-ordered conference may be held at any time in the proceedings and may also be held on more than one occasion in a proceeding. With the implementation of a court case management framework, we may see this occurring in deliberate and strategic ways. For example, using a conference early in a proceeding to try and resolve a discrete issue, such as a dispute about an application for an interim order on contact or placement, or trying to resolve a factual dispute relating to the threshold issue about whether or not a child is in need of protection. Another area in terms of focus for the amendments will be the withdrawing of applications for child protection orders. A new section, 57 capital A, will clarify that once an application for a child protection order is before the court, leave will be required for it to be withdrawn. This is essential because at the time the order was applied for, the applicant was satisfied that the order was necessary to meet the child's protection needs. Therefore, if the application for an order is to be withdrawn, there will be a requirement of the applicant, so that being the Director of Child Protection Litigation, to explain to the court why the order is no longer necessary to protect the child. This may be, for example, because the child's circumstances have changed and the child no longer needs protection, or because the child's protection needs can now be addressed without the need for an order. The court must be satisfied that the order is not or is no longer required before granting leave to withdraw. Another key focus of the reforms come 1 July will be on the role of non-parties in proceedings. The Child Protection Act defines parent broadly for most purposes as including a person having or exercising parental responsibility for a child. The broader definition encompasses people who are regarded as a parent of an Aboriginal Torres Strait Islander child under Aboriginal tradition or island custom. However, parent is defined more narrowly for the purposes of court proceedings, effectively excluding a range of people who would meet the broader definition from having a right of appearance or entitlement to be served with filed documents. The inquiry received submissions from a range of legal stakeholders about the limitations created by this approach, and in particular its disproportionate impact on Aboriginal and Torres Strait Islander families. The final report recommended that the Children's Court be given discretion to join as parties to a proceeding members of the child's family and other significant people in the child's life in appropriate circumstances. This recommendation will be implemented by significant amendments to Section 113 of the Child Protection Act. A person will be able to apply to the Children's Court to make an order that the person is allowed to participate in a proceeding. When the court makes the order must say how and when the person will take part. It may be that the person is allowed to participate for the whole of the proceeding or for part of the proceeding stated in the order. The order may provide a particular provision of the Act applies as if the person was a party. So for example, Section 70, which requires that parties must attend a court order conference. It may also provide that all provisions of the Act apply as if the person was a party. The Act will apply to the person as if they were a party to the extent provided in the order. So these amendments will really enlarge and enable people who to date have been a significant person in a child's life. So those people that prior to intervention were exercising or having some form of parental responsibility for a child will be in a position now where they can make an application to be allowed to participate in a proceeding. Another part of the focus of the amendments is going to be in respect of long-term guardianship. There's going to be a requirement for the court to be satisfied in respect of the child's case plan when making a long-term guardianship order. So the Child Protection Inquiry noted that before the court makes a child protection order, the court must be satisfied that there is a proper and child and case plan in place. Well, the court does not specifically endorse the living and contact arrangements in the order. The court has to be satisfied that they are appropriate before making the order. The inquiry recommended that the Court Case Management Committee consider if it's feasible for a court making long-term guardianship orders to also make orders about placement and contact in respect of children. The Court Case Management Committee considered the issue and concluded that it wasn't feasible for courts to make such orders, and that it is in children's best interests that child safety remain empowered to change placement and contact arrangements promptly in response to a change in circumstances, rather than being required to return to court for a new order each time a change is required. However, the committee recommended that the Act be amended to make explicit that before making a long-term guardianship order in particular, the court's consideration of the appropriateness of the case plan must include being satisfied that placement and contact arrangements are appropriate at that time. These recommendations are being implemented by by amending Section 59 of the Child Protection Act, so that in addition to the court being satisfied that the case plan is appropriate for meeting a child's protection and care needs, before making a child protection order that would grant long-term guardianship, the court must also be satisfied that the case plan includes the living and contact arrangements for the child. Another focus of the amendments will be that a parent may request a review of a case plan for a child on a long-term order. So if a child protection order provides that child safety should be the long-term guardian for a child, so that being the chief executive, the case plan must still be reviewed on a regular basis. However, if the guardian is another person, so akin to the child, somebody significant, the Act currently provides that child safety must simply contact the child once a year about the plan and must consider reviewing the plan in response to any request from the child or their guardian. So that's Section 51, capital V, capital A. If child safety, on receiving the request, decides not to review a case plan in response, this decision is a reviewable decision that can be that an application can be made to the Queensland Civil and Administrative Tribunal, QCAT. A request by a parent for a case plan to be reviewed is currently not reviewable in QCAT in these circumstances. So considering the situation and a recommendation from the inquiry that a new review right be created for where a parent or a child requests that the appropriateness of a long-term order itself be reviewed. As a result, an amendment will be made to Section 51, capital B, capital A, providing that parents may also request the review of a case plan when a child has a long-term guardian, and that this will be a reviewable application that can be made to QCAT. Another area of focus for the reforms come 1 July is QCAT and applications for review of decisions in respect of contact. So the Child Protection Inquiry recommended that the Child Protection Act be amended to allow the Children's Court to deal with an application for review of placement or contact decision to be made to QCAT if it relates to a current proceeding before the Children's Court. This would ensure that as many issues as possible relating to a child are dealt with in a single forum by a decision maker with access to all relevant evidence, rather than having similar issues for the child being considered in two different forums, that being the Children's Court and QCAT, where there was potential differences in the evidence and the parties before each. Following this recommendation, a new Section 99, capital N, capital A, is going to be inserted into the Child Protection Act, which will require QCAT to suspend a contact review if there are child protection proceedings before the Children's Court, and QCAT will have to notify the court. On receiving notification, if the court then makes an interim contact order, judicial order resolving the substance of the QCAT review, that being the decision about contact, the review at QCAT will then be dismissed. If, however, the court decides that the matter should remain at QCAT, or the court proceeding is finalised without an interim order, an interim contact order being made, then QCAT may then deal with the review proceeding as normal. So that brings to an end my comments in respect of the major reforms, and I'm really going to open it up to any questions or comments that you might have in respect of these court-focused reforms.
Terrific. Thank you, Nigel. A reminder, folks, that there are a couple of ways that you can ask questions. One is to type a question into the questions box, and the other is to press the button that looks like a hand on your control panel, and and we'll see your hand go up. We can unmute your microphone and you can ask Nigel a question directly through your phone or your computer. I might just start off with a couple of questions to get things rolling while you're gathering your thoughts and entering questions here. My first one, Nigel, is around the changes for non-parties. Yes. It's not uncommon for community legal centres to see grandparents coming in wanting to have a role in the child protection system, in child protection litigation, that kind of thing. You talked about the rights that non-parties might have in through changes to court laws and those kind of things. In terms of the practical steps that we might advise a grandparent or some other family member or person that's been in the young person's life, what are the practical things that we would be telling them about how that application works for them to be recognised as or recognised under these changes?
So I'll start in response, James, by just confirming what has been the status quo in this area, and that is that currently somebody that doesn't meet that narrow definition of a parent does not have a right to appear or participate in the proceedings. So Section 113 currently provided a ground on which a person could make submissions to the court about the proceeding, and as part of those submissions access some information or documents to assist them in their submissions, but it was really a limited role. The new provisions, like I was saying, are going to enable the court in appropriate circumstances to effectively grant people the ability to do all things, so they'll have all the responsibilities and all the rights of a party, so they will be able to participate in the proceeding in full, including filing of evidence, being served with evidence, and questioning witnesses and making submissions. But in terms of practically what does that mean on the ground for giving advice to extended family members such as grandparents, it's anticipated that the remade Children's Court rules, which will need to be in place by 1 July, will give further guidance around this issue. But I would think that there's going to be an ability to file an application or to attend a court on the day and make an oral application. So be advising people that they should be allowed to or be able to attend the court and are going to be able to make applications orally from the bar table. There will need to be some thought around what it is or what role those people would like to play, and really what it is that they're seeking to achieve by being involved in the proceedings. It might be that they're going to consider themselves as a potential custodian or even a guardian of the child, and so that might then guide the level of participation they would like, or they might simply have very strong views on what should happen in respect of the child, and so they might just still be seeking to access maybe some documents and make submissions.
And in terms of legal representation for those non-parties, are they likely to be able to apply for a grant of aid or access child protection duty lawyer services? Or
that's a very good question, James. It's something that's currently being considered. So the first point is that somebody that's in that fits that category of a 113 person, they are able to be legally represented. As to whether or not there are going to be either an amendment to legal aid's grants of aid or a new grant of aid created, that's yet to be determined. But at the very least, I'd be encouraging people to be familiar with where legal aid currently has child protection duty lawyers operating. They are in some key courts across the state. It's where you find the specialist children's court magistrates sitting. At the very least, those people should be accessing the duty lawyer to get some assistance with what they should be saying in terms of their oral application on the day. And all I can say is just in the lead up to 1 July, check in with Legal Aid Queensland's website, grants of aid, and we should be making it very clear whether or not and on what basis somebody in this situation might be able to apply for a grant of aid.
On a related theme, and it might be again a slightly premature question, direct representation of the subject children in these proceedings. So what capacity is there for representation or funded representation?
So currently, right now, children can be directly represented. The Act is simply just providing more guidance around that lawyer, what their role is. Children right now can make an application to legal aid under the current grants of aid, provided the child has the capacity to instruct a lawyer. The child is going to meet both the means and merit test. If the proceedings they're involved in involve an application for an out-of-home order, and I should just note on this point that even children right now that are in care under child protection orders, they too can contact legal aid for advice, and if on receiving advice they would like to make an application for direct representation, they can do so, and they could have a lawyer engaged for, say, a specific purpose of negotiating with child safety over a residence, like a placement or contact issue, or have a lawyer come along with them to a family group meeting that's going to be reviewing their case plan. That's something that currently happens right now, and the Act is really just making it very clear that we are going to have situations where children are going to be represented at the same time by two lawyers, that being a separate representative and a direct representative, and that currently happens. Yeah.
Right. A reminder, folks, a couple of ways that you can ask questions. Type a question into the questions box or raise your hand. Nigel, a question here. How does a party ask for directions for disclosure?
Very good question, James.
Well done, staff out there.
Yeah, so the Act is, like I've noted, establishing a disclosure regime as to how a party is going to ask for disclosure and the time frames on when disclosure will occur and on what basis. It is anticipated that will all be covered in the remade Children's Court rules. But yet for the first time there's going to be a continuing obligation of disclosure on the new body, that being the Director of Child Protection Litigation. But it's important when thinking about disclosure is to separate out that concept and material that's filed and served in court. So it won't be that everything that's disclosed will be filed. So it might be that material could be considered relevant, but the director may not consider it necessary to file, but they will still make it, if requested, available for parties or non-parties who have been given the status, so that being the rights and responsibilities of a party, to request for that material to be disclosed. And then, as I touched on at that point, there is an obligation then on the director, if they are making a decision to refuse to disclose a document or information, they'll be clearly articulating on what basis refusal is being taken, so on what basis they're refusing to disclose. And then the Act is going to then provide for an application the party can then make to the court for there to be a determination on the disclosure issue. So if at first instance a document is withheld, the party can apply to the court, and through that process it can include the court on actually receiving the document to make a determination on whether it should be disclosed and on what basis. But again, the remade Children's Court rules will put a lot more scope around the steps that will be involved in this area.
Just a clarifying question on that, Nigel. So does that mean disclosure will not ordinarily happen unless a request is made?
I anticipate that we will have a scenario where there will be key documents that are just routinely disclosed. So it'll be something that, like what you see in practice, for instance, in the United Kingdom, where there's just key documents that, as a matter of course, are routinely disclosed but not necessarily filed. And then there'll be a process in place to allow more targeted requests made for disclosure. But again, this is all something that's yet to be clarified exactly how it's going to work.
Thank you. A question about whether non-parties can make a QCAT application. You talked about the role of QCAT. A QCAT application for contact or for children to live with them?
Right. So in terms of QCAT, so the provisions, the amendments that are being made in respect of QCAT really relate to that scenario where you've got a family that's in the children's court involved in a proceeding for a child protection order where children are already in care under either a previous substantive order or an interim order that gives the chief executive custody or guardianship of the child. So when the chief executive, that being child safety, has that power, they get to make administrative decisions about where the child lives and what sort of contact they have. So the focus of the inquiry and the amendments is really trying to bring together those corresponding or those parallel proceedings wherever possible, so it's just the one decision maker making that decision. So for legal reasons at the moment the amendment is just proposed to transfer contact decisions, so it's really where the QCAT proceeding is involving the people that are also involved in the children's court proceeding, so where you're just getting a judicial determination of the issue. But going back to the question, like QCAT, so there is standing for people to bring applications of reviewing QCAT that are much broader than the currently refined number of parties in the children's court, and I'll try and explain it this way. So at the moment, when there's a decision made around a child's contact, so if it's a decision that refuses to allow contact or restricts contact or imposes conditions on contact between a child and the child's parents or a member of the child's family, any person affected by that decision has standing to bring an application for review. So if there's a decision made that restricts a child's contact with their sibling can bring an application for review in QCAT. If the decision currently restricts the grandparent's time with the child, the grandparent has standing. Likewise with placement, so when there's a decision made about a child's place, anybody affected by that decision, that being really the child, the child's parents, or the carer, have standing to bring an application in QCAT. Now the question which I'd not considered prior to the issue I'd not considered prior to the question is whether or not if a non-party acquires the rights and responsibilities of a party in the children's court is also got standing in QCAT, whether the matter will be transferred and dealt with that way. Is a good question, it may. So if the QCAT proceeding relates to contact, so if the applicant in QCAT is grandma, she's brought a review of an application to restrict her time, and grandma's also been given the rights and responsibilities of a party, so she's under order in the children's court, well there's no reason why the matter shouldn't be transferred over. But I'd have to look at the exact provisions. But I hope that answered the question.
I think it did. A reminder guys, again, a couple of ways you can ask questions. Type something into the questions box and that's where these questions are coming from. Or press the button that looks like a hand on your control panel. We'll unmute your microphone and you can ask Nigel a question directly. Nigel, kind of a simple and obvious question in some ways. Will the amendments apply to existing child protection matters where proceedings have already been commenced and are in the court process? So questions around kind of transitional provisions.
They will, and so come 1 July, any current proceeding before the court, the amendments will apply. So there could be as many as 900 current applications that are before the court that suddenly will be dealt with under these new provisions come, not some will, they will be dealt with these new provisions come 1 July. As to what that will then mean in terms of the big issue that I can foresee that will have to be thought about and have to be managed by the parties in the court will be disclosure. So if you have a matter that's been before the court for a significant amount of time, it is foreseeable that the disclosure issue is going to be raised by one or more of the parties, and it'll have to be, I think the court at times is going to be asked to play a role in case managing that issue.
Terrific. Nigel, I think that's all the questions that have been sent through so far. So I might just give people another minute, another few seconds to either raise their hand or type a question into the questions box.
So I think the other thing I'd just make it really clear is that the two new bodies that are going to be established being the Director of Child Protection Litigation and also the new administratively established Office of the Official Solicitor within Child Safety. This is big change. It's well, and I made the point it's unique within the Australian child protection system, so states and territories. The new model will essentially be the director making an independent assessment based on evidence of whether or not an application should be brought, and if so, what type. So we're no longer going to have a model where when it gets to child protection order applications, an instructions model. So the director is not going to be acting on the instructions of child safety. Of course, the director has to take into account the recommendations of child safety, but it really is an independent assessment of the evidence, which is unique. Yeah.
Nigel, I think we're done. Thank you. That was, heaps of change in this space, and I think getting our heads around what those changes are going to mean practically for those of you working in the space is pretty tricky, but will be aided hugely by this presentation and also, I suspect, harassing Nigel with questions over the next little while.
I should say that Legal Aid aims, it's proposed on the 29th of June, Legal Aid will be putting on a further really focused continuing professional development event that'll be also by webinar, that's the hope, where hopefully just prior to the changes some of the issues I wasn't able to give a lot of context about will have been resolved. And so if people are available, watch this space. Happy to receive any emails by James or by you directly about that event, and I'll seek to include you once it's all finalised.
Terrific. I'm getting comments coming through, Nigel, like you rock and very informative, so that's terrific. Can I, on behalf of those people and everyone else who tuned in, thank you for the presentation. Thanks out there in cyberspace for participating, folks. We'll see some of you at the Fragmented Family CPD Day next week, which is now sold out or oversubscribed, I guess. But we'll also distribute some of the resources that come out of that day to you if you're registered and provided your email address. Thanks very much. Have a great weekend, and we'll speak to you soon.
Thank you.